number 230-576-1901, people of the state of Michigan versus Quentin Woolfolk. Counsel.
For the people, 272748.
And Ryan Marat, PA 3665, on behalf of Mr. Quentin Woolfolk, waive reading statement. Mr. Woolfolk is advised his rights.
Thank you, counsel. The court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. Positions as to bond, please.
Your Honor, for Mr. Woolfolk, we do not have an objection to personal bond.
Thank you.
Personal bond being imposed. Mr. Woolfolk is 25 years old, no prior, no pending matter, not employed, within the guidelines, stable residence.
Thank you. Mr. Woolfolk's bond is set at $10,000 personal. You are not to purchase or possess any firearms or other dangerous weapons during the terms of this bond. Your next court date is going to be a probable cause conference in front of Judge Robbins on July the 10th. After that, preliminary examination is set in front of Judge Sabree for July the 17th. Again, do not purchase or possess any firearms or other dangerous weapons. Thank you.
Not bad. Go ahead. Go ahead. Yeah. So your full name?
Kareem Cleveland May.
Good afternoon, Mr. May. This is case number 230-576-2001. People of the state of Michigan versus Kareem May. Counsel.
Thank you, Judge. Good afternoon, Steve Benson for the people.
Ryan Marat, PA 3665, on behalf of Mr. Kareem May, waive reading statement. Mr. May's been advised of his rights.
Thank you, counsel. The court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. I will hear arguments as to bond.
Thank you, Judge. The people in this matter are going to be asking for $50,000 cash, no surety, with tether and house arrest if the defendant were to close. Your Honor, the people would like to note that after reading the investigative report, things just didn't add up, and I'm sure Your Honor may have felt that way after looking through the investigative report. We had two different accounts of actually what went on. Now, when the people are in this kind of position, what they like to do is reach out to the complainant in this matter, which we did. And as a result, Judge, we have a better understanding of what actually occurred in this matter. The complainant at the time of this incident was on the phone with dispatch the entire time. Your Honor, the injuries that the defendant allegedly sustained were a direct result of him breaking through the window, and that's what ended up causing all of the blood and gashes that he ended up having. The complainant in this matter had a child, which this defendant shares with the complainant. She was in the house as well. Your Honor, the complainant feels as though she is in danger as a result of this particular defendant. The injuries that the defendant sustained, again, were a direct result of what he ended up doing. Your Honor, she ended up talking to dispatch, and there's a call out there, which I'm sure will come out in the litigation of this matter, that is going to corroborate all of this. Not only that, Judge, just for housekeeping matters, this defendant was charged with felonious assault in, Your Honor, 2017. He was also charged with domestic violence in 2020. Both of those cases had to do with the same complaint that's in this case. Now, Your Honor, the felonious assault case ended up getting dismissed because the complainant ended up not appearing because she was scared. In the domestic violence case, Judge, that actually ended up just being adjudicated early this year after, I believe it was, the offense date was in 2020, after 4 habeases by this defendant failing to appear. Ultimately, the complainant, again, never ended up showing up for trial because she was scared. And now we have 4 months later, after the adjudication on that domestic violence, and we have these charges in front of us today, Judge. It's the people's position that everything is going to be corroborated. We took a substantial amount of time talking to the complainant. There is a high likelihood of conviction in this matter, Judge. The people do feel justified in asking for that cash bond. We do feel as though this complaint is in danger. She also has a child. The glass, actually, Judge, that the defendant ended up breaking still hasn't been completely cleaned. They have a 1-year-old child, and she can't even have her 1-year-old child in that room because of the damage that this defendant ended up causing. So there is Your Honor, a danger that we believe the defendant possesses in this case, and we feel justified in asking for that cash.
Thank you. For the defense?
Your Honor, on behalf of Mr. May, I would indicate that, first of all, any cases that were dismissed and used against him is, I believe, violating his right to be presumed innocent on those cases that were dismissed. Additionally, I want the court to know that he's 31 years old, Your Honor. I believe he's a life person in the community. He gave for his word at Lower City Casino. Your Honor, it's important to work with this investigator's report because it did at least a bit of the side of the story. If somebody is so guilty, you're not going to go to the police station and try to report the complaining witness. He said that there were other parties involved. Now, I understand that people called the complaining witness, but they called the same person who assisted with this report being authored in itself. Obviously, the complaining witness is going to repeat her same story, and obviously, Mr. May's going to repeat the same story. But that's what court's about. So the question is whether or not Mr. May deserves to be held without bond or held on a high cash bond while this case is pending. Judge, I'm looking here, and I'm sure the people will correct me if I'm wrong. I don't see a presence of threat. I don't see an alleged injury. So I have my guy, my defendant, who's going to the police station himself and making his own report, trying to tell his side of the story. I understand that the argument is that the complainant was on the phone, that may be why he went to the police, or whatever the argument may be, but nonetheless, I don't think a flight risk is fair here because he was arrested in the actual police station. And any danger to the community, I don't think presents to the community. If there's an issue between Mr. May and his child's mother, Judge, I'd ask that there would be a no contact order and there be maybe a tether. But I don't think a high cash bond here is necessary. Again, I don't believe that this complaining witness is credible. I think if she shows up this time and tells her story in the side of court, it'll get flushed out. But Mr. May is maintaining his innocence. He waived his right to remain silent, and he spoke to the detectives, Your Honor. He told the side of the story. That's when he was arrested. So that's for consideration in setting up.
Your Honor, just briefly, there wasn't any injury because the complainant was in her house. Once she ended up seeing the defendant allegedly breaking in, she ended up contacting dispatch. In fact, Judge, it was the complainant who was relaying everything that the defendant was doing real time. Not only that, Your Honor, there was clear danger here. There was actually a brick. Subsequent to him breaking the window, he ended up leaving the residence once he saw, allegedly, that the complainant was calling the police, ended up throwing a brick at the window while the complainant's face allegedly was close to that window. She was in fear. Her daughter was in fear. We felt it in her voice, Your Honor. And I know this is something that will get flushed out, but this defendant, just based on the history, the felonious assault, the domestic violence, and this complainant being a part of all of those incidents where this defendant was alleged. And just to correct defense counsel, we weren't bringing those up, and I can understand where this court may not use a dismissal in this matter, but even in those particular cases, there were multiple cases. So what the people were trying to show was that there is a flight risk on top of what the people are arguing is a substantial, sorry, Your Honor, danger.
Thank you.
Judge, a brief response. I did have the opportunity to look into something. I heard brother counsel allude to the fact that the complaining witness was scared. That's why she's not showing up to court. Well, I had the chance to run her name in the register of actions, Your Honor, and she's got 24 failures to appear on traffic misdemeanors. Now, I understand I don't like that being used against my client, but when we talk about things like scared to come to court, I think that that's something that
maybe that's why she's scared. She's got warrants. Okay, so nevertheless, I've heard the arguments. Based upon the arguments, I do deem Mr. May to be a danger to the complainant. Just like I don't believe people stab themselves in the back. I don't really believe people are in the business, especially those with small children and ongoing expenses of breaking out their own front windows, car windows, etc. So I do believe something happened. Mr. May says other people did it on the complainant's behalf. Again, there's broken windows, there's injuries, there's things that lend credibility to the fact that something happened here. And I've got to try to decide based upon what's in the investigator's report. Was it what she said or was it what he said? I think there's more support, quite frankly, for the record counsel, if it comes up, given the fact that there are previous charges involving the same person with domestic violence, felonious assault, when I have to try to figure out who's telling the truth here, I don't know, but that it keeps coming up does cause me concern for the complainant's safety, and that's what I have to assess at this time. $50,000 cash is the amount of the bond. GPS tether with full home confinement if he's able to make the bond. Bond review hearing Monday, July the 3rd in front of McConico, July 7th for probable cause conference, July 12th for preliminary examination. No contact or attempted contact with the complainant, meaning no verbal contact, no written contact, no contact through third parties or social media. Any attempted contact would be considered a violation of the conditions of the bond. The last two court dates, July 7th and July 12th, are scheduled in front of Judge Giles, while the first is again in front of Judge McConico. Thank you.
Thank you, Your Honor.
Okay.